Colleagues, as a settlement, this comes straight to council as an emergency ordinance, so there is no committee staff summary or chair report. But we do have Mike Porter and Rose Radich here to remind us of the basics before we hear public testimony.
Good afternoon, Council. We are asking Council to approve a settlement in the case of Gregg versus City of Portland. This case stems from a 2015 conviction for heroin distribution. Mr. Gregg pled guilty and served over 4 years in prison for that offense. While Mr. Gregg committed the crime, the key issue in this litigation is how miscommunication led to his guilty plea. At the time, the district attorney handling the case believed that someone had died after using the drugs Mr. Gregg had sold. That information turned out to be wrong. City records show that the DA had been told the victim overdosed but survived. However, at least one police report incorrectly referred to the person's death, and another was later changed to say the victim had died. One of the responding officers, Matt Brown, actually performed CPR at the scene and likely saved that person's life. His original report accurately described the victim as alive when submitted. Unfortunately, it appears that during a clerical records process, Officer Brown's report was modified to indicate that the victim had died. It then appears that the DA and defense attorney both proceeded under this mistaken belief that someone had died. That misunderstanding influenced Mr. Gregg's decision to plead guilty. Years later, after learning the person survived, he filed this claim, his case, claiming that he was misled. The prosecutors have been dismissed from the lawsuit due to immunity, which means that if this case went to trial, the city would be the only remaining defendant. That creates a real risk that a jury, wanting to hold someone accountable, could place full responsibility on the city. A verdict against the city could result in millions of dollars in damages and attorney's fees. The proposed settlement, $300,000, avoids that risk and reflects the calculations used in Oregon's wrongful conviction statutes for similar cases. Finally, we would like the council to know Mr. Gregg has turned his life around. He is now a student at Lewis and Clark Law School and spends some of his free time volunteering in the community. The city believes the settlement closes a difficult chapter for everyone involved, recognizes the mistakes that occurred, and reflects Mr. Gregg's rehabilitation. For those reasons, we recommend the council approve the settlement.
Thank you very much. Ms. Radich, do you have anything to add?
No, thank you.
Okay. Councilors, any questions on the content before we hear from the public and then move into discussion? Okay. Seeing none, Keelan, do we have anybody signed up for public comment?
Yes, we have 4 people signed up. I'm going to call them 3 up together who would like to approach the testimony table as a group. Mark Porras, Philip Chachka, Charlie Michelle Wesley.
Welcome. Thank you all for being here today. You are welcome to begin as soon as you're ready.
Thank you. Good morning, Council. My name is Mark Porras. I use he, him pronouns, and I'm with the group Portland Cop Watch. Since 1992, Portland Cop Watch has been working towards a police bureau that's free of brutality, corruption, and racism, and this item falls under the corruption heading. We understand the parties have come to an agreement, and we have no objection to the city writing a check for $300,000 to settle this civil rights and malicious prosecution lawsuit for an event that happened over 10 years ago on May 23rd, 2015. This is different from the usual cases we testify on, people in mental health crisis who call for help and are killed by PPP like Michael Townsend, mistaken identity and the inherent racism in policing like that of an unarmed black man, Manny Clark, who was shot in the back and killed even though PPP was looking for white men, and the many individuals brutalized by police while expressing their First Amendment rights, including the 9 journalists and legal observers who are plaintiffs in the Index newspaper's lawsuit. This one's different. Maxine Bernstein wrote about this case last September, and the Oregonian's editorial board followed up shortly afterwards with an opinion piece titled, "A Lawsuit to Hold the Justice System to Account." The story, according to court documents and the Oregonian's reporting, is that Mr. Gregg and another man, Mr. Cook, were both sentenced to prison for their roles in selling heroin to a man who died of an overdose, or so they were told by 2 Portland police officers and 2 Multnomah County deputy district attorneys. The glitch was that the man did not die of an overdose, although police reports written by PPB officers Carrie Hutchison and Tequila Thurman said that he did, and the deputy district attorneys used that misinformation to get both men to agree to plea deals and serve time in prison. In fact, according to court documents, Officer Thurman was told by the girlfriend of the man who overdosed that the man was still alive the very same day of the overdose. 3 days later, Officer Thurman wrote a report that omitted the fact that the man survived the overdose. Officer Hutchison's report, written the following day, noted that Officer Thurman interviewed 2 individuals who had been with the man the night before his death. Mr. Cook was sentenced to 366 days in prison and in May of this year received a judgment in his federal lawsuit awarding him $45,001 plus costs and attorney fees. According to city officials, these amounts don't yet appear in the monthly city administrator's closed claims report because final billing and related expenses associated with the claim haven't yet been paid. According to court records, Mr. Gregg filed this lawsuit to obtain compensation for the 5.5 years he spent in prison, believing he had killed a man, all based on the defendant's lies. Now, I neglected to mention that Mr. Gregg did not learn that the man was still alive until after he was released from prison and had gone looking for the man's family to apologize and seek their support for his plan to go to law school. The corruption exposed in the DA's office on this case is now a separate and it's ongoing piece of litigation as Mr. Gregg has appealed the court's dismissal of the deputy district attorneys from the suit. Today's settlement, though, will end the city's involvement if it's approved. A district attorney's office's work is always preceded by police work. According to the Oregonian's reporting, the lead prosecutor stated that he simply believed what was in the police reports when negotiating. When the police work is negligent or incompetent at best and corrupt at worst, people will be over-prosecuted or falsely prosecuted and lose their liberty in the process. Thanks. Mr. Chachka's up after me.
Hi, my name is Philip Chachka. I use he, him pronouns. I am also with the group Portland Cop Watch. We appreciate the inclusion of the Bureau claims data along with the ordinance, which states that the 1-year total paid out to claims for the PPB is more than $5.7 million, not including this settlement of $300,000, the associated $45,000 court judgment plus attorney fees for Mr. Cook, and not including the Manny Clark settlement of $3.75 million. Once paid out, it will push the total to at least $9.75 million this year. This ordinance does not mention it, so for the record, the Multnomah County Court case number is 23 CV 44189. We are disappointed that after reading this ordinance, a person could have absolutely no idea what terrible things happened that caused the city to settle for $300,000. We hope the city will provide greater transparency in the future. According to Section 2 of this ordinance, it is classified as a bodily injury lawsuit. Only this is not a bodily injury lawsuit. That is a copy and paste error in fitting for a case in which 2 officers wrote faulty police reports. Until the Community and Public Safety Committee starts hearing these cases, we support Councilor Canal's request for increased transparency on these settlements, and that the full council continue to discuss the policy decisions or violations that keep us coming back to testify on police misconduct cases, in the hope that future harm can be prevented. This ordinance states that no public involvement or input was sought and no future public involvement is anticipated or necessary. The community is deeply impacted by police corruption incidents such as this one. If you want community to trust the police bureau, then the police bureau must be trustworthy. Here are some potential lessons for the community for this case. When the police knock on your door, it might be better not to answer. If the police give you information, do not expect it to be the truth. Be wary of officers' ability to write factually accurate police reports and prosecutors' ability to verify the facts of the case. If you are sentenced to prison in part because the police said you killed someone, do some research and find out if that person is still alive, because the state and police may have failed to provide basic facts of the case and exculpatory evidence as required by law. At the PCC EP meeting tonight, they will be discussing the exculpatory evidence directive. Chief Day wishes to weaken the directive and risk more cases such as this one. The city should provide all exculpatory evidence to the DA proactively and not wait for the DA to ask about police witnesses that might be unreliable. Thank you.
Good morning, Council. I'm Charlie Michelle Wesley, a member of many Northwest tribes here, and I'm here with Portland Cop Watch, but including personal input. So where do things stand now with the police officers who lied to Mr. Gregg? Officers Thurman and Hutchison are both still employed by PPB. We do not know if either officer was disciplined for falsifying information, as neither officer has a case listed in the DPSST's Professional Standards and Economics sanction database. What we do know is in October 2024, Officer Hutchison was promoted to sergeant. However, we are pleased that Mr. Gregg is in his third year at Lewis and Clark Law School after serving nearly 5.5 years in prison. His display of ingenuity turned this injustice into a means to protect and serve others. We greatly appreciate that Mr. Gregg volunteered to serve on the Portland Committee for Community Engaged Policing, PCEP, although his term was cut short, as we understand it, because the city attorney claimed there was a conflict of interest due to this lawsuit. We remember Vice President Koyama Lane's words during deliberation on Manny Clark's settlement. She said, "When trust is broken and needs to be rebuilt, I believe as a value that those who have been harmed really need to lead the way in what that rebuilding looks like and also get to decide when there is real change." This is exactly what Mr. Gregg was trying to do when he volunteered to serve on PCEP, when the city attorney removed him from that committee. We bring this up because the city is currently performing background checks on the already appointed members of the Community Board for Police Accountability. It is no secret that there are appointees with criminal histories. Who better qualified to shape true accountability in policing than those who have firsthand knowledge of the harshness of the system? A system that includes a moral character policy of honesty, and if out of policy, consequences supposed to be termination. However, barriers to actual accountability is aided and abetted by the same suppressive injustices. Another PPB principle, procedural justice, states, involves giving people a voice and being trustworthy. But Mr. Gregg and others with that actual truthfulness are removed to keep the truth from succeeding. Amartya Sen talked about procedural justice, and I quote, "In seeking resolution by public reasoning, there is clearly a strong case for not leaving out perspectives and reasonings presented by anyone whose assessments are relevant, either because their interests are involved or because their ways of thinking about these issues throw light on a particular judgment." And in closing, as a recovering addict for 25 years myself, the primary reason recovery programs are so effective is foundational principles of honesty. With PPB without honesty, the remaining principles are meaningless and continually lead to lawsuits which are not accountability nor justice, and keep some of the most ethical, knowledgeable community voices overpowered and often with tragic outcomes. Thank you.
Thank you all for being here.
Next up, we have Jared Essig.
Welcome. Thank you for joining us.
Good morning, City Council and Multnomah County District Attorney, if you're listening. My name is Jared Essig. I'm appearing on behalf of the citizens of Portland and Multnomah County and representing the Rose City Iron Front. In September 12th of last year, 13th, the day after Oregon Live exposed this prosecutorial negligence or corruption and the police misconduct that resulted in this unjust incarceration of Mr. Gregg, I appeared before Multnomah County presiding judge Judith Matarazzo in an ex parte off docket hearing, and I asked her to adopt the policy that had been proposed by Senior Deputy District Attorney Kelly Rhodes, but had been not adopted by the District Attorney's Office. And she agreed, miraculously, and it's now verbally ordered, so ordered by the Multnomah County court, that they will not accept a negotiated plea offer unless, in a case involving a homicide, unless there is a proof of death in the form of a medical examiner's report or a other affidavit testimony from some reliable witness. And now, that should have been done by the prosecutor in this case. That's why this whole qualified immunity thing has to be eroded, because the DA's office is the primary culprit in this misconduct, not the city. And you should direct the city attorney to work with me to hold the district attorney's office accountable and to ensure that the judges abide by Judge Matarazzo's verbal ruling that she made to me. I'm going to appear tomorrow before her again with a written order and ask her to memorialize that and institutionalize it in the local court rules. I'm a pro se litigant, and I'm a amateur lawyer. So it'd be nice to have some professional legal advice and help in my public advocacy efforts, which will save the city money in the long run. Now, I want to shift. Oh, also, the court records are sealed. I couldn't get court records for State versus Gregg or State versus Jeremiah Cook. This violates the Oregon State Constitution's Article 1, Section 10, which guarantees the right to a public trial, as well as the U.S. Constitution. Justice is not a cloistered virtue. We need to see these records to understand what happened and hold our public officials to account. I also want to shift gears a little bit and say a lot of leaders want to hide behind the police and then blame them when things go wrong. That's not okay either. We need moral and intellectual leadership from people like yourselves and from the judge. Now, authoritarianism, anarchism, both support each other. It's really easy to blame the federal government while refusing to deal with the problem of the ideology of violent revolution, and which is very popular in Portland. In fact, terrorism is more popular than the police are. Okay, so declare a curfew at the ICE facility. It's really easy. You can avoid the deployment of National Guard.
Thank you very much. We appreciate hearing from you today.
That completes testimony for this item.
Thank you, Keelan. Colleagues, we will now move into any discussion before taking a vote on this agenda item. Councillor Canal?
Thank you, Madam President. So I do have a question for Mike. It wasn't a technical one, so but I'll just build to that. So first and foremost, I do agree with a couple people who said that this issue was primarily but not exclusively a county issue. But I also want to point out that due to state law providing prosecutors with near absolute immunity from civil liability, the county and DA's offices had the cases against them dismissed. In other words, while the DA's office and police officers were both originally respondents to this lawsuit, it's now just the police officers involved that we're addressing here. And I want to point out to my colleagues, I personally believe, and I mentioned this in our work session on the legislative agenda, that prosecutorial immunity to this level is ridiculous. Multiple advisory groups to this council have recommended that the city take a stand on this issue at the state level, and I would like to see the city's Office of Government Relations instructed through the legislative agenda to lobby on an ongoing basis to eliminate it. And this is also something that I believe would support our police officers' ability to be held to a standard that is fair for them. Related to that, but a little different is my question. There is a portion of this that was alleged in the lawsuit to be a responsibility of the city, of PPB. So I want to ask two questions. One is, have there been any policy changes as a result of cases like this one? And was anything done specifically with, and I want to stress with, not to, has anything been done specifically with the officers involved on this particular case?
Thank you, Councillor Canal. So to your questions, yes, as a result of this case, there have been modifications, some of which were alluded to in the testimony, specifically that there will be confirmation of death when death is part of the case. As to the report writing, there's been continued training. I would also respond, I think, and it's appropriate to your question, that there were investigations into this. That's how we know that Officer Brown, for example, had his report was accurate and then was modified through the system. Officer Thurman has been on leave since before this litigation commenced, and so that investigation is on hold. And Officer Hutchinson had a sustained finding for misinformation ending up in a report in violation of a directive. So that's sort of consequences as a result of this.
Thank you very much. The only other thing I'd like to mention going forward is I do agree that we should mention two things in the documentation for settlements. One is the case number. I do think that'd be very helpful for the public and frankly for counselors to do our own homework on it as well. I know it's often provided elsewhere, but and the other piece is if there are related cases. I did not know about the case related to Mr. Cook until I got an email from a constituent referencing a $45,001 settlement there that because it's under $50,000 did not come here. Yes. So for those who don't know, $50,000 and above come to City Council now. It used to be $5,000 prior to January 1st. So I think having that be involved in it would be very helpful, and I'd ask, I guess, it's probably not you or your office, Mike, but the risk management folks, whoever files it. So with that said, I guess the question before us, to me, is does an open confession to a crime and conviction, selling heroin that resulted in an overdose, lose you your civil rights, lose you your right to be given the accurate information about the impacts of that crime? And I think the obvious answer is no, which means I think the obvious answer to this vote needs to be aye. Thank you.
Thank you, Counselor. Colleagues, I just want to note on the record, there's a question raised in testimony about Section 2 of the ordinance itself, which talks about bodily injury. What the attorneys have shared with me is that we categorize claims in two ways, either bodily injury or property damage. This more closely aligned with bodily injury. While that's not exactly what happened, that is the category it would fall in as opposed to property damage. So that's why that's listed in the emergency clause. I don't know if either of you want to speak to that at all, or if we should just move on to the next question.
Yeah, just briefly, that is sort of how the claims are set up, is there's kind of two buckets that they can go into: property damage, kind of reserves and claims, and bodily injury. So bodily injury ends up having to cover emotional distress, civil rights violations, employment claims, things that aren't what you think of as like a physical injury. It definitely is something, though, where we could change the wording if we want to have it kind of clarify a little bit, even if that's just how it's set up in our system and how the templates get set up. We could change the language to reflect more clearly what it is, if you'd like.
Thank you for clarifying that. It may be that that's more of a broader forward-looking issue. Councillor Clark.
Thank you, Madam President. I don't have a question. I just want to make a statement. I'm not very happy about this settlement generally. I don't want to vote to reward an admitted drug dealer at one point. I'm also someone who had a felony on their record and had that erased earlier in my life. But I've heard from other counselors here on the dais outside meetings that Counselor Smith, Counselor Novick, and others that point out that this person turned their life around. I also recognize that pursuing this could potentially cost the city a lot more than the cost of this settlement. So I will reluctantly be voting yes on this. I also want to take exception to some of the testimony we heard this morning, that I think that saying this is corruption is really an overreach. Maybe it was sloppy on the other end of the continuum, but I don't think it was corruption. So I just want to say that. Thank you very much.
Thank you, Counselor. Counselor Smith.
Thank you, Madam President. I believe this settlement is an important reminder that how we do things is as important as what we are doing. As city officials, we must hold ourselves to a higher standard because the public put full faith in us to do so. This individual paid his debt to society while living with the guilt of taking a life he did not actually take. I couldn't imagine what it feels like to have felt that you, for 5.5 years, that you killed someone and you didn't. I admire the drive, the tenacity of Mr. Gregg, and putting himself through law school is exactly what we would want for people who have served their time. This is exactly what I want, and I think the system that help people rehabilitate themselves is the system that I want to be a part of. And we have to be held accountable when we mislead folks as we're trying to prosecute in our very hurried lives. And we have to be very careful how we do things. It's not because of what he did, it was how we enacted as being the person who is in charge and the person who is supposed to be doing things by the book. And I don't know if it's overreach that the previous Cop Watch folks said that it was corruption. Well, I think it's somewhere in between, but it is definitely something we should not do. It was definitely, as we looked at the data, it was put in two different places. So we have to be held accountable for that. And I appreciate Mr. Gregg being able to rehabilitate himself, and I'm looking forward to see what he does with this law degree. Thank you.
Thank you, Counselor. Counselor Zimmerman?
Thanks. I just have some questions. How many prosecuting attorneys does the city of Portland employ?
None, Counselor.
None, okay. Did we prosecute this case?
No, we did not.
Okay. For the distribution of heroin, what is a standard jail sentence that a person would get if they pled to that?
So I'll answer your question. There's a sentencing guideline or grid that the courts use, and they recommend, or the presumptive sentence, that's the language they use. In this particular case would have been 80 months.
Say it again.
80 months.
80 months. Okay. So in your estimation, does the jail sentence that this person served for distributing heroin match the normal course of what a drug dealer would have received?
Counselor Zimmerman, I think that to answer your question, I would say that the presumptive sentence is the sentence that the court was presumed to give when under these facts. Mr. Gregg's allegations are that at the time he felt that given the court's posture that he would have been able to get a reduced sentence if he'd been able to argue this point and didn't know it. I think that's the distinction between the two sides of this argument.
Okay, that's helpful. If a person is facing a drug dealing charge in our courts, does the guilt of the drug dealing itself matter with respect to whether or not a person who purchased those drugs died or did not die? Is drug dealing illegal whether you live or if your victim lives or dies?
It is illegal, and the charge in this case, an element of it was not the status of the victim.
Okay. One of the testimonies received was malicious prosecution, and I know that a lot of Portlanders center their public safety concerns at the city, but I want to use this opportunity to remind folks that the city of Portland does not prosecute any cases. In fact, it's an entirely different government who prosecuted this case. To me, this looks like a failure on behalf of the defense attorney. It looks like a standard jail sentence for a person who's convicted of dealing drugs. I am concerned that we are continuing to cite turned their life around as a reason why in this situation where some false information was in a police report is an argument for a payout. That is troubling to me. I think that if we're on the hook for any misinformation in a police report from the moment for something that a different government prosecutes and that a person cops to and pleads guilty to, that if they don't turn their life around, would we not be in a situation where we would settle? This seems interesting to me that that's coming up. But if I would be far more comfortable making this settlement agreement if you were here telling me if the person had served a sentence related to the death of another human, but that's not what I'm seeing in any of the documents or any of our briefings that we received, that the sentence was served unrelated to the death of a person. Because distributing heroin, it wasn't distributing heroin, comma, someone died. I guess I'm concerned about a precedent that we'd be setting as a city that after you turn your sentence, if you can find any Scribner's errors, any information errors, anything at the point that the city of Portland is the piggy bank to come to and not Multnomah County, who has the duty for investigating and negotiating plea deals and prosecuting cases. I don't want to say that the information in those police reports should be ignored. I think my colleagues have made really good points about that, and you've indicated some changes there. What I'm failing to understand is why, when there's another government who prosecuted this case, a judge who put out this sentence, a defendant who pled to this charge, why this lands here. So given all of that and this idea that we're going to negotiate with drug dealers, I feel very dissatisfied with being brought this settlement. I think we should go to trial. I think Portlanders expect us to go to trial. When you do the time for the crime you committed and pled to, I don't see the concern here in the way that it's been described in these documents. So I do appreciate that we've gone into some detail previously. I thank you for that. I appreciate your professional opinion on this. I'm uncomfortable with just how many or I guess our aversion to going to court on some of these. I think it would be in the best case for us to say, you dealt drugs, you did your time for dealing drugs, not for killing a person, and they can make the case in front of a court. But I won't be supporting the settlement. I understand there is considerations about greater loss, et cetera, but I do think there is a point in which we have to look at some reasonable facts here that we're being sued by a person who did time for the crime they committed and which they pled guilty to, and it had nothing to do with the death of a person. But somehow we're letting that false fact come in and say that because of that, their dealing of drugs is somehow not something to be held accountable for. So I'll stop there. I do appreciate folks their comments that have been made. I think they're all well put. I agree with Councilor Clark. I don't expect that there was other undercurrents in this. I think that mistakes happen and we've dealt with that, but there are other checks in terms of prosecutorial, and this is 3 DAs ago, by the way, I'll say, not the current DA, not the last DA, but the one previous in 2015. So I think that this case should rest at Multnomah County and not the city of Portland, and if the case needs to be argued, I think that that's the right place for it and not these chambers, but thank you.
Thank you, Councilor. Councilor Novick?
Thank you, Madam President. First of all, my inclination is always to go with the city attorney's recommendation as to a settlement when they're saying that if we don't settle, we have a risk that the taxpayers will wind up paying more. There are some circumstances in which a proposed settlement seems so morally abhorrent that I would say, no, let's roll the dice, even if that means the city pays more. And I understand people being concerned about making a payout to a drug dealer. However, I want to second the point made by Councilor Smith, which is that this guy spent years under the impression that he had killed somebody. And unless he is a complete monster, then suffering under that impression for years is, to me, likely to have been at least as painful as if he'd been savagely beaten by police officers. So I want to assume that most people even drug dealers, are not monsters. So the fact that this guy suffered for years under the impression that he had killed somebody, to me means that despite generally, I wouldn't want to give money to drug dealers, the city attorney's recommendation is not morally abhorrent. So I fall back on my general idea that as a matter of fiscal responsibility, I defer to the city attorney's judgment as to what the financial risk is.
Thank you, Councilor. Councilor Smith, we'll get back to you after others have an opportunity to speak first. I hate to do that when I'm next in the queue. That's a bit awkward, but here we are. I appreciate the comments that my colleagues are making. I want to be clear that when we're talking about a settlement, it's not about Mr. Gregg. It's not about his past. It's not about his future. It's not about whether he's a good guy or a bad guy. And it's also not about whether the sentence was right. It's about two things. Is it likely that we messed up in this case in a way that may have affected his civil rights? And what is the legal risk compared to the cost of settlement? And I want to make two things clear. I don't believe that we should be taking the ultimate responsibility for this. I think the facts of the case show that the real responsibility rests with the county and the DA's office. And I believe that we have amazing city employees who do incredible work for Portlanders every day, and nothing about this case changes that. But because we have amazing city employees, we have to hold ourselves to the highest standard. And when we fall short of this standard, we have to make it right. And in this case, I believe that there's enough risk that we fell short of our standards, our legal standards. And there's enough risk that the cost of moving forward would be greater than the cost of settlement. And therefore, I think the natural conclusion is that we need to approve this settlement. Councilor Murillo?
Thank you, Council President. I definitely agree with everything that you stated and that Councilor Smith stated before us. I think the reality is that the law has to be dispassionate. So this is not about our personal feelings about Gregg as a person or a member of our society. This is about whether or not his due process rights were violated, and his due process rights were violated. And while this wasn't being handled within the city of Portland, we do have some responsibility. It was our officers that lied about whether or not he had killed someone. And I think most people who have any compassion in their hearts, regardless of the life that they lead, would be concerned, upset, and have long-lasting emotional damage if they thought that their actions had led to someone's death. So I also just want to push back on some of the comments that we heard previously, because our legal system is not consistent, and judges often use their discretion to make decisions about people's lives. I think there were multiple studies done that show that weather changes can impact whether or not a judge is going to give a harsher or lighter sentence. If someone's sports team loses, they could give a harsher or lighter sentence. People are very complicated, and there is a lot of discretion in how people make decisions. That changes day to day. So someone being apologetic for what they have done, I think absolutely impacts a judge's discretion in this. So we at the City of Portland, we're responsible for our police and the things that our police say and do, especially if it can impact someone's sentence long term. And we do have to take responsibility for that. I also think that we really have to, I really appreciate Councilor Clark sharing part of her history here with us today. I think that's extremely powerful, and she's a city councilor now, and I'm happy to serve alongside her. And that means that when we say we're negotiating with drug dealers, what does that mean when someone has served their time and is now doing different things and has a law degree? They're not a drug dealer anymore. They are a person who is doing something different with their life, and they deserve to move on and to be a productive member of our society. So we have a responsibility here. We have a responsibility for our police. We have a responsibility to move through this without passion and to just say, are we partially responsible for this? And our police are, and we are responsible for our police. So I am going to vote to approve this settlement, and I hope that that people understand that no matter who you are or where you come from, you deserve to have your civil rights protected. You deserve to have due process. And at a time where our country is actually taking away so many people's due process, I hope that the City of Portland will show that no matter who you are or where you come from, you are owed that in a just society. Thank you.
Thank you, Councilor. Councilor Smith?
Thank you, Madam President. And I just want to go back and piggyback what Councilor Murillo said. Under the Constitution, we are granted due process of the law. Under the 14th Amendment, we are granted equal protection under the law. And I want to ask you a question. I'm sure we don't have the tape or the transcripts to show, but I bet you $1 to a donut, Mr. Gregg was told, if you do not take this plea deal, we're going to charge you with murder. You gave us 80 months as a possible timeline of what he would have spent. 80 months is 6.2 years. How much would he have gotten if he was charged and found guilty of murder?
So, Counselor Smith, I'll speak to that. The presumptive sentence for the drug charge was 80 months. There was, in fact, a written offer from the DA's office to his attorney that said, if you don't plead, there will be potential federal charges. And those federal charges, when not murder, would have brought many more months or years of time in a federal prison, not a state prison. And some of those would have been likely, based on the record, related to the death of the person who overdosed. So yes, it would have, he was threatened with a longer sentence.
So we can safely say, without this plea deal, he was looking at a lot of time. And so he made a choice to take the lesser of time, which he was afforded due our Constitution, right? And he was getting everything that anyone who was in this position would have been able to receive. There's a negotiation, there's a deal when you're doing this. And so I agree. You don't have to agree with what the person did. We don't like it. It has the potential of causing all kinds of things with our kids and our grandkids and those kinds of things. But at the same time, if our police gave information that caused him to make this decision, I'd say in addition to the DA's office, we are equally responsible. So today is not about, like our council president said, this is not about if we like this person as a person. This is about equal protection under the law. Thank you.
Thank you, Counselor. Counselor Canal.
Thanks. A lot of my colleagues said a lot of what I was going to say, so I'll just hit it quickly. Strongly support Counselor Smith's assertion about our high standards and holding ourselves to them. I agree with both Counselors Clark and Zimmerman about frustration with the county's lack of responsibility here, and we'll talk about the legislative agenda when we do. I agree with Counselor Zimmerman's point that turning your life around or not is sort of immaterial to the question of the settlement itself. It's a nice to know piece of information, and I appreciate hearing about it. But I think that even if this plaintiff had done the same stuff after his sentence was completed, the question is immaterial to the settlement. The settlement is about, did we create a harm and would we be paying it? Or in this particular case, is there a risk that a court would find that? So that makes sense. I will say one last thing, which is that I really appreciated the conversation about whether or not this was corruption or a mistake. From my read of the record, it did appear to me to be a mistake on behalf of the officers. Personally, that was my most likely outcome takeaway here. And I think that it's still important to hold officers to a standard of conduct that's been set without necessarily saying you did this intentionally, right? That's a criminal question sometimes, but not necessarily in our administrative context and also not in the civil context. Having said that, I totally understand why there's a lack of trust. And I think that's really important to look at the patterns of why people might be saying that in our conversations and our testimony. I understand why people might come to their own conclusion that it's more likely than not that something wrong was done here. That doesn't mean I agree. I just understand that there's been enough distrust created over the years to see how it's easy for someone who doesn't have all the information we have, in part because we don't necessarily give all the information that we have, might get there. And I think it's a perfectly fair assessment, even if I don't necessarily agree with it in this case. And I want to close by thanking Councilor Murillo for saying exactly what I was going to say, which is that due process matters to everyone, whether it's any of us up here, Mr. Gregg, or an immigrant. We need to be standing up for universal rights and principles. Thanks.
Thank you, Counselor. Seeing no one else in the queue, this is an emergency ordinance. It requires 9 votes to pass. Keelan, could you please call the roll?
Clark.
Aye.
Green.
Aye.
Zimmerman.
No.
Avalos.
Aye.
Dunphy.
Aye.
Smith.
Aye.
Canal.
Aye.
Ryan.
Aye.
Koyamaline.
Aye.
Maria.
Aye.
Novick.
Aye.
Turtle-Guinea.
Aye.
The ordinance passes with 11 yes votes and 1 no vote.
Thank you, Keelan, and thank you to our legal and risk teams for their work on settling this case.